All right, good afternoon, everybody, from a very sunny London. We are here in that very brief interlude between it finally being possible to have a drink outside and the railway system falling to pieces. It's a brief window, but we're enjoying it. We have decided to do this webinar on whistleblowing because it seems to us to be a growth area. We've got more and more clients, both domestically and internationally, who have staff who blow the whistle and generate whatever rights we have as a result. There is also stakeholder public demands for accountability and greater employee confidence and so on, and nothing we have seen says that that isn't going to continue as a trend. So today we're going to talk about the wider world in whistleblowing terms. This is going to be followed by two more webinars focusing on continental Europe. To start with, introduce panel for today. So we have Marga Caproni, partner in Brussels, who's going to talk about the position in continental Europe. That's only going to be pretty high level because there is a European directive which all the member states are implementing in fractionally different ways as we speak, pretty much, so that will necessarily not go into a lot of detail. Julia Yeo, partner in Singapore, she's going to very bravely cover essentially the whole of Asia Pacific, China, Hong Kong, Japan, Korea, Singapore, Malaysia, Thailand. So Julia will be speaking very quickly indeed. Kim Hodge, partner in Perth, who's going to talk to us about Australia. Kim will not be standing up during this webinar in order to hide the fact that he's in his pajamas. I can't imagine what time it is in Perth at the moment, but thank you, Kim, for that. And finally, Catherine Liao in New York, who's going to be talking about the position in the US. Now, a few quick housekeeping points as usual before we start. All the participants, that is you rather than us, will be in listen-only mode. There is a facility for submitting questions. I don't have a dog's idea how that works, I'm very sorry, but if you follow the instructions and you submit questions, we'll get to them if we can during the session, but time is tight. If we don't get to answer your question during the session, then look out for a response to it via the Squires Employment Law blog over the next couple of weeks, where we will certainly try to pick it up. Finally, we will be submitting a recording of today's session after the webinar. So if you miss any of it, then please, you get a recording and you can go on from there. So I'm going to start, just for comparative purposes, by talking very briefly about the position in the UK. Until the whistleblowing directive in the EU, the UK's whistleblowing legislation was some of the more sophisticated in Europe. Pretty much overnight, it feels as if we've become the least sophisticated in Europe instead. But the basic premise of the UK legislation is that whistleblowers, put bluntly, are a nuisance. This is the very opposite of the basis for the European directive, which is that they are to be encouraged. So the UK whistleblowing regime is very, very limited. It says simply that somebody who blows the whistle, and only a very small set of people can blow the whistle in terms of employees and workers. You will hear more from Marga about the wider populations in Europe. Their only right really is not to be retaliated against. So there is no right to feedback, there is no right to an investigation, there is no right to reward, there is no right that anything happens at all. And in UK law, as a result, as things stand, it will be completely lawful, not good practice, I hasten to add, but completely lawful to receive a protected disclosure and do absolutely nothing about it at all. Now that's under the whistleblowing regime. There will be exceptions to that where something ought to be done because it'll be a problem later, health and safety in particular, perhaps under the financial services regime. But our starting point, the UK position, is that it is entirely a passive right, a right not to be retaliated against. And that's essentially where we start. There is potentially unlimited compensation, although it will be buttons compared to the US position. You don't need 2 years service to bring a claim, so in that sense it's better than ordinary unfair dismissal, but it's not very developed. It's enough by itself to generate quite a lot of legal work in the UK, so it remains to be seen what more developed rights create outside the UK. So to begin to look at that, I think, could I ask each of you to give a very, very quick, sorry, Julia, but a very, very quick overview of the whistleblowing landscape in your country, your region, and anything really, really high level that international companies ought to do. So perhaps if we could start, maybe Julia, start with you in your whistle stop tour of Asia Pacific, and then Kim, and then Catherine, and then Marga.
Sure. Thanks, David. So I think Asia is a mixed bag of legislations, really. I mean, mostly countries don't have a specific whistleblower legislation or framework, but we really have more fragmented piecemeal laws that provide protections for certain types of disclosures. Although I will have to say Japan and Korea are much stronger in this area. I'll touch on these two countries later. So let me start off with Singapore. That's where I'm based. We only have like the Penal Code, Prevention of Corruption Act, and the Corruption Drug Trafficking Act, which kind of provides some protection for informants of certain crimes, right? And protection under this legislation are also quite different. For example, our Prevention of Corruption Act gives you anonymity, but not the Penal Code. So it does mean an employee who whistleblows on certain wrongdoings, that is not corruption related, will find themselves excluded from the anonymity protection. So just that's high level. In Singapore, interestingly, I was just reading some statistics that because the perception that the government is pretty transparent and will take action on corruption and bribery actions, there is a high level of willingness among Singaporeans to actually whistleblow. So it's quite interesting. Other ASEAN countries like Thailand, Philippines, Vietnam, they are quite similar to Singapore, no particular legislations. Just again, a fragmented piecemeal legislations protecting whistleblowers in very specific situations. Malaysia and India both have a Whistleblowing Protection Act, but unfortunately that's only for the public sector. So public servants like the Royal Malaysian Police, the Anti-Corruption Commission, the Custom Department, those are subject to disclosures for the whistleblowers. China does not have also a whistleblowing legislation, but interestingly, over the recent years, they have tried to advance in this area. So some of the actions we see taken will be like a guiding opinion that's been issued by the State Council. They require central government ministries and provincial governments to establish whistleblower protection systems, but again, also public sector. You have also the Ministry of Finance, for example, issuing a measures for rewards for whistleblowers. That's done in December 2021. So that's quite interesting because they will award whistleblower successful, complaints. They can be awarded a monetary sum up to RMB 1 million. That's about what, USD 157,000, right? If you satisfy certain conditions. In Hong Kong, I have expected there to be a whistleblowing legislation, but actually no. They would have some code of conduct for listed companies that they must establish whistleblowing mechanisms. It will be, of course, a criminal offense. Let's say if an employer dismiss or discriminate against an employee for giving evidence or information in a public inquiry relating to enforcement actions under the Employment Ordinance or under the Discrimination Ordinances. So it's very specific. It's not a broad whistleblowing legislation. So let's move on. Japan and Korea buck the trend. Like I say, they do have whistleblowing protection and pretty strong ones. Japan has a specific whistleblowing protection act that protects employees who whistleblows, right? So it protects them from dismissal or detrimental action, meaning, demotion, salary reduction, or other types of disadvantageous treatment. Such disadvantageous treatment or dismissal will then be deemed invalid, and then they get reinstated or compensation. They even have compensation for mental suffering. Although it's not a huge amount, it's probably about $5,000 to $14,000 USD. Korea has a Whistleblower Protection Act. It has been recently amended to expand protection for whistleblowers. Previously, it covers only 284 statutes, but now it's been doubled up to 467 statutes. So some of these statutes include the Korean Anti-Discrimination and Disabilities Act, the Gender Equality Employment Act. These are the employment-related legislations that whistleblowers get protection from when they whistleblow. So if you look at it, it is a mixed bag. I mean, there are some advancement we hope to make in the ASEAN countries in particular. Nothing quite like the EU directives, unfortunately, at this point in time, but we can see improvement and advancement, just like we see in China. So that's it for Asia.
All right. Kim, a short hop to Australia.
Thanks, David. Look, I guess whistleblowing in Australia, it depends a lot on which industry or sector you're in, and the nature of the disclosure that the person wants to make. So in Australia, we don't have one single law that provides overarching protection for whistleblowers, and there's no positive statutory duty on employees to make any report of malpractice or fraud or corruption, etc. So in Australia, there's been a number of high-profile whistleblowers over the years, many of them from the public service, and unfortunately they speak up and traditionally have sort of lost their job. And in a couple of high-profile cases, they're being criminally prosecuted by the Australian government. Now, this is because they've gone to the media first, rather than following a proper whistleblowing process. And generally, there are some exceptions, but a disclosure to the media doesn't constitute a complaint to an appropriate body, and so it's not protected. So we have very defined requirements around what is a whistleblowing complaint. And broadly, Australians, if they do blow the whistle, they have a right to be protected, but broadly they are on their own. They've got to have the legal resources to defend themselves and go to court. So in Australia, we have no reward system for whistleblowers at all. We do, have one side of it, and on the employment side of things is the Fair Work Act, and private sector employees there can make what they call as a workplace complaint, which could include a whistleblowing type of complaint, and they are broadly entitled to protections under the employment legislation there. So, to make a protected disclosure, you have to be of a certain type of person, so an employee or a former employee. It has to be against a particular entity, and in Australia that can be against banks and superannuation or pension funds, and against some companies of a certain size. And you have to disclose to a particular type of person, and which can be a lawyer, but as I said, not normally a journalist. And the kicker, which sounds like other jurisdictions have as well, is that the whistleblower has to have a reasonable ground to make the disclosure. So this is where it gets interesting, because there's often a personal work-related grievance, so that wouldn't be protected. So if you can jump all those hurdles under the Corporations Act, you can get protection. You're protected against legal action. You can be protected against detriment, like losing your job, etc. But often you'll need to have the legal means to defend or take action. And and you can seek some compensation through the court, but I wouldn't say, David, that that's particularly common. So in a nutshell, it's complicated, it's risky, and at least in the private sector, there is an avenue to do it in a different manner, but not through traditional sort of, or the formal whistleblowing legislation.
All right, thanks, Kim. Catherine, I think we were going to go to New York next for a quick overview of 52 states worth of whistleblowing law.
Thanks, David, and good morning to those in the US. So we have less hurdles, I think, to overcome than Australia, but under the federal regime, there are a few key statutes, the first being the Whistleblower Protection Act, and that's exactly as it sounds. It's a federal law which prohibits persons with authority over personnel actions from taking or failing to take a personnel action in retaliation for specific actions by an employee or applicant. So whistleblowing and retaliation claims are inevitably intertwined. Ultimately, the whistleblower statutes protect employees and applicants and sometimes, contractors from retaliation for whistleblowing. And whistleblowing includes blowing the whistle on any violation of the law, essentially, under the Federal Whistleblower Act or the Whistleblower Protection Act, with various caveats. So for example, if it's required to maintain confidentiality with respect to certain information, et cetera, then, the conduct may not qualify under the statute. Then we also have the False Claims Act, which authorizes private parties to bring what's called a civil qui tam suit, seeking reimbursement on behalf of the government against entities who allegedly have defrauded the government. So various, prima facie elements, if you will, before you can assert that. And I would say those are less common, but certainly can result in significant liability. Then we've also got the Department of Labor. The Federal Department of Labor protects employees against retaliation for blowing the whistle in terms of violations under various statutes, from safety and hazard guidelines to harassment, discrimination, hostile work environment. And then there are also other federal statutes that may be applicable depending on the sector you're in. So for example, many people have probably heard of the Sarbanes-Oxley, which applies to employees and agents of publicly traded companies, right? So there's various protections depending on the sector you're in. Then we've got certain state laws, and those can be even broader than the federal statutes. I think most notably California and New York. Unsurprisingly, I have yet to be able to say that I'm not busy because I practice in California and New York, and there are a lot of rights for employees. Now, California has codified a Whistleblower Protection Act in its California Labor Code. Right? Again, tied to retaliation, there needs to be some sort of causal connection between the protected activity or whistleblowing and the adverse action. New York has its own state law as well. New York City actually has its own protection. New York notably has amended its whistleblower protection law as of January of last year, 2022. And it is incredibly broad to the point where you may not even need to disclose the wrongful conduct to the employer. So there doesn't even need to be a disclosure. And how, you may ask, how can that be? Well, if the employer had reason to know, then you don't need to disclose, or you suspect that the employer already knew, or if it will result in significant harm. Again, incredibly broad and puts employers in a pretty tough position, from an employer protection standpoint. So, just a highlight of some of the protections in the U.S. and, certainly we are known perhaps to be a little bit more litigious than other jurisdictions. So employers do need to be conscious of these amendments.
Well, if litigious means the right to sue for being penalised for not saying something because the employer already knew it, then it's impossible to disagree. By the way, I apologise for the halo which I've developed. Rumours of my divinity are overstated, just to be clear. But anyway, so Marga, to Europe, if if we can.
Absolutely. So I think it's fair to say that, at least in continental Europe, we didn't have much of a whistleblowing tradition, potentially up until now. I think the first time we were actually confronted with the notion of whistleblowing was mostly through US influence, and then the first time where European legislation actually kicked in was with the directive for the financial services sector. That was in 2013. So we had to wait until 2019 to get that directive that has been mentioned a couple of times now. So member states had until 2021, December 2021, to implement that directive. That's the way it works with EU legislation. If it's a directive, the member states need to implement. They had some freedom in certain domains within the directive to implement as they deemed fit under local legislation. What we saw is that most member states did not observe that deadline of December 2021. For example, Belgium took another year to actually implement its legislation. By now, most member states are up to the point where they have the legislation in place. I think we're still waiting for Luxembourg, but the majority of jurisdictions now have legislation in place. I would say in terms of setup, it's a very traditional piece of work, the directive. So important to note probably that the scope of the directive is not whistleblowing on any type of matter. The aim of the directive was to enhance the enforcement of EU legislation. So whistleblowers can report on infractions of EU legislation only, but there was the possibility for member states to expand. And so you'll have the traditional areas such as consumer protection laws, competition law, data protection. These are all EU governed matters. But in addition, member states could go beyond that. And for example, Belgium, my country, has opted to also include matters of tax and social fraud, because we are notorious for being very active in those regions. So the scope is limited to EU law. Then the second chapter of the directive, so to speak, is provisions on where the whistleblower can report. There is a chapter on internal reporting, so within the company. And in addition to that, if internal reporting doesn't generate the necessary results, then the whistleblower can also go to, or he may opt automatically directly to go to the state service to do an external reporting. And if that doesn't generate the necessary results, the whistleblower can go to the media to report. Now, on the internal reporting and the obligations that employers have to have this channel, there isn't all that much in the directive. And what we see is also that local legislation hasn't necessarily added much to that. But as a general rule, we can say that companies as of 50 employees need to have an internal reporting channel. Companies between 50 and 250 employees, they can share resources as it's put in the directive, so they can have one channel in common just for the receipt of the reports. And companies as of 250, they cannot share resources. They have to have their own internal channel, but we'll come to that later on in more detail. And of course, the third chapter in the directive is on the protection against retaliation. As David already mentioned, the scope of the whistleblowing directive is quite large in terms of who can do the reporting. It's anyone who has in some kind of way professionally interacted with the company. So it's employees, it's state officers, it's interns, it's students, it's self-employed consultants. Basically, anyone can make report. And of course, then there is the protection against retaliation, which I would say is also rather classic in the way it's set up, but is quite large in its scope. So that, in a nutshell, is continental Europe.
All right, thank you very much, Marga. So next stage, I have a series of questions to ask around the world. Catherine, can we start with you? In terms of the practical handling of whistleblower complaints, that sort of, oh dear, it's landed in HR or it's landed on the line management's desk, what do I do now? That moment there, what would you say would be the best practical tips that you could offer?
Erring on the side of caution and conducting a thorough, fair, and prompt investigation from the U.S. perspective, and determining whether or not you have the resources and expertise in-house to do that type of investigation, or if you should refer it to an external investigator or, your law firm and get referrals to have your employment counsel retain an external investigator. So I think that's critical. Oftentimes, employers are they aren't able to identify the need for an investigator, and that can put you in trouble. And depending on the type of concern raised, some states even have an affirmative duty on the employer to conduct, to basically prevent certain types of conduct, such as harassment, discrimination, or retaliation. So failure to conduct an investigation can create liability in and of itself.
So the answer to the employee, oh God, not you again, what is it this time, is probably not a smart one.
No.
Okay. All right. Anybody else got a sort of immediate practical tip for that moment where it thumps into your email or onto your in tray? What should managers, HR, legal, what should they do right there, right then?
I think so, or already mentioned, keeping calm is probably the best advice that we can give. It's not the end of the world. You have the time to collect the information. Yes, there is a process to be complied with, but take your time and don't do anything rash is probably the most important tip that I can give.
Yeah, to echo that, and David, in terms of what not to say, certainly don't say, oh gosh, go away, here you are again. But also, you should not just automatically assume it's the truth or, engage, oh my gosh, I can't believe that happened to you, that's awful. Maintain objectivity, especially if it's HR, you're going to be the one conducting the investigation, or, oh, I knew so-and-so was awful to begin with. This just affirms it.
Yeah.
Yes. Kim, Julia, practical tip?
Yeah, David, I think in Australia, confidentiality is critical, and we've seen a few times where, office holders will talk, and before you know it, it's out in amongst the business, and you've breached your fundamental obligation of confidentiality there. So it's about understanding people's roles, keeping it confidential until things can be clarified. And also we find a large degree of managing expectations. In Australia, people think that they can sort of drop this bombshell and run away and it will all get sorted out. But it's managing expectations of the business and of the whistleblower themselves as to how it will be handled.
Yeah.
Sure.
Julia?
I was going to add that, knowing the local legislation is really important. For example, let's say in India, which is a very clear case that anonymous whistleblowing will not be entertained actually under the Sexual Harassment Prevention Act. So, I mean, much as companies would like to encourage employees to whistleblow by promising anonymity, it's not going to be allowed under certain acts. India's Whistleblowing Act as well, anonymous complaints are not entertained. So you need to know what to do when you do receive an unidentified whistleblower, right? And what do? Can you then extract the correct complaint out, encourage them to come forward so that you can investigate rightly under the legislation? Time frame is, of course, very important. If you're receiving a complaint, to know that you don't disqualify the company from the investigation because you failed to comply with the local laws on the time frames and the manner of investigation.
All right, thank you. I will add two to that from the UK perspective. One, as Margaret has said, is don't panic. A disclosure can be a good thing for the business. it isn't something that you have to should adopt an immediately defensive posture to. The other things, certainly in the UK, is don't make your first steps being checking whether the disclosure is protected or not, whether it complies with the legislation, because bluntly, the only reason you want to know that is to find out whether you can retaliate or not. So it doesn't matter whether it's legally protected. That comes later down the pipe if you do something daft in the process, but it shouldn't be your first thought. Your first thought is, here is something, we need to get to the bottom of it. Kim is quite right to say that there are duties of confidentiality, both express and implied, so keep a fairly tight lid on it. You do face the possibility, coming back to the expectation management point, that the employee will not drop the bombshell and run away, but will drop the bombshell and then run around the office with it saying, "Oh, look what I've done," in order to basically maximize their protection. It's a different approach. It's very difficult to stop them doing it because, of course, action taken to prevent that sort of thing is so easily confused with action taken in retaliation for it. So certainly in the UK, where disclosures can be made in terms which are hostile, aggressive, unreasonable, none of those form a basis for not dealing with it properly. I presume that the same is true worldwide, but if anybody disagrees, then say so now. Nobody disagrees. Splendid. All right. So, Kim, question for you. Many among the audience will be international companies with offices all over the place, headquarters somewhere in the world, and the whistleblowing incident perhaps 12,000 miles away. Is it a good idea to have a single policy for the whole global workforce, or is it better to have jurisdiction-specific local policies?
Thanks, David. I think I got the easy question, but we did discuss this as a group from Squires, and hopefully you'll back me up. But I think we all agree that practically it's going to be really difficult to have an overarching global policy that covers all these different jurisdictions. You know, you've heard from Julia, Catherine, Margaret, and David. It's just a lot of it is similar, but there are so many nuances there that I think it's not possible, is my opinion. I think it may be possible to articulate some global principles, and to touch on what you said, David, you know, essentially this is all about doing the right thing. People are coming to you broadly to disclose something that they think is wrong. So you can have some global principles, but really I think you have to go back to the local jurisdictions. They are very nuanced. So no, I don't think it's feasible to have a global policy.
Yeah, beyond the broadest of principles, I think that's right. What about having this is to sabotage the easy question point, but what about having not a global whistleblowing policy, but a central body for handling disclosures wherever they're made? So if you are US headquartered, all disclosures go to the US. So some of my clients run a thing called ethics points, which automatically feeds complaints to a central source. Is that a good idea?
Well, again, I would suspect, David, that we're going to have a diversity of opinions. I've had clients that have that centralized reporting system. It works well for them because it's a central repository, so to speak, and that you're not dealing with it on a local level. So there's not these conflicts. There's not the issues with confidentiality. There's not conflicts with, you know, telling the boss that something's come in or reporting structures. So it's worked for those organisations to have a external organisation that can be reported to. But I think we might hear from some of the other participants here that that doesn't necessarily always work that well.
Yeah, it's interesting because I think we were well aware in Europe that was what was happening, that was the way that international companies were already organized. But somehow the European directive has completely ignored this reality. And so the possibility of having this one channel is not an option in the directive. And there's been questions to the European Commission as to how we should understand the directive and what should we do with those global reporting channels. And the Commission has put forward a very strict position, which basically comes down to saying you need to have something in place in each local entity. But on top of that, yes, of course, on top of that, you can do the global channel, provided that your local entities are no more than 250 employees. But if that's the case, then yes, indeed, on top you can have a global channel, and you can even encourage employees to report to the global channel, but they should always have the possibility also to go locally. They've also considered the possibility that you may want to invoke the resources that you would have at headquarters, for example, to investigate the matter, but there again, very strict rules on informing the whistleblower that their information will be sent to headquarters, and the whistleblower should at any time have the possibility to retract the report and have it dealt with at a local level. So it's really as if the European legislator was not willing to look at this reality of the global reporting channels, unfortunately.
Which is very strange, because you would think that the fear that misconduct might be reported up the pipe to an international parent would be a strong steer to behave correctly.
Yeah, well, the concern apparently was that employees at local level were not necessarily always aware of the fact that there was the possibility to report to a global channel. And so the idea behind this very strict European position is to say, if there is the obligation to have something at a local level, employees will be more aware, and that will increase the chances of whistleblowing reports effectively coming into play.
Yes.
That was the idea.
Argument.
But that's really interesting, isn't it? You know, I'm just going to offer a perspective from the Asia portion, because local offices in Asia for MNC are generally quite small, isn't it? Satellite offices, you know. So it is always not easy, rather, to make a complaint anonymously, for example, right, without being identified easily. And so it is really quite prohibitive or difficult for an employee to come forward. And the person being complained could very well be the local MD, the big decision maker. So my experience with several of my clients, that local employees have a greater willingness to whistleblow if they know that they can go outside the local chain of command. Right. Of course, you need to balance that with, you know, whether the global chain of command or the person holding the, you know, receiving the complaints, whether they understand local context, nuances, you know, whether they are able to cope, essentially. I do recall a case where my clients, the governance officer, right, receiving the blowing reports are in US, and they are floundered because they told me they receive hundreds of complaints every day from their India offices, right? Because I think there's a poor understanding perhaps of what is a, you know, whistleblowing situation, what is a grievance, but it was sending all the complaints. But so it could, of course, it could be a very genuine case, right, where they feel that they are very much they have difficulty reporting locally, and therefore having a global command would be a much better place to do that. So I think it's a question of confidence, right, in the process, confidence in the channel. That makes a difference whether you should have a regional, local person, or should you have that global contact person.
Yes, and also from the point of view of the employer, there is the potential that the person in HQ somewhere simply doesn't understand the sheer lack of, I mean, this is talking mostly about UK law, but we had a case where a disclosure was made to a head office overseas. It was something potentially, but not actually, very serious. And the legal team in the overseas headquarters just lost their heads over the whole thing and produced this grossly over-engineered resolution, which in fact generated far more fuss and noise and publicity than it need have done. So, I mean, there are arguments both ways. Clearly, it's something which employers will need to work out for themselves, except obviously in Europe. Yeah, so long as it functions, that will be the key question. So long as it addresses proper needs and produces reasonable solutions, I guess that's the main thing. All right, Julia, if I may, practical tips more broadly, perhaps in relation to the pre-whistleblowing stage. Is it a good idea to train managers how to deal with it, for example?
Oh yeah, definitely. I agree with that. I think one of the key points I see is about training managers to identify what is a whistleblowing situation, what is a grievance, right? Knowing how to handle it and directing it to the right channels for investigation or for mediation and conciliation is really important. I mean, we talk about, in fact, about, identifying the right person to be the governance officer will be important. It has to be somebody who is clear-minded, calm, able to dissect the complaint, right? To understand what it pertains to. That's really important. And if I can also go back into, talking about setting up the process, right? I think one of the good things about setting up a mechanism is really to allow multiple ways of making a report. You have employees who are very comfortable with an online portal. You can have employees who are very resistant to that and do not want to leave a document trail but want to speak to somebody in person. So I think having multiple ways of allowing a reporting is important. But that when it leads to the point that you actually may need more than just one officer, isn't it? You need a team of people to handle this aspect of whistleblowing. So in terms of training, I think that really is important. I would say training not just for the officers, but really training for the entire workforce to understand that they have a speak up mechanism, to know who to direct it to have confidence in the whole process is very important in ensuring that you have a useful policy, a practical and implementable or usable policy. I wanted to make the point also that in view of the fact in many of the Asian legislations, there's going to be rewards given for whistleblowing, a successful whistleblowing situation. So you want to encourage employees to whistleblow to you instead, right? Rather than to go external and expose the company. So that confidence in the local, in your own company process where whistleblower know that actions will be taken, disciplinary sanctions will be implemented, no matter how powerful the offender can be, right? That will be very important in protecting the company's interest, reputation, finance exposure whatsoever. Yep.
Right, Julia, you mentioned, and also Kim touched on the same point, the distinction between a protected disclosure and a grievance, and Kim referred to just a whinge about one's personal contractual position. How do you distinguish between a disclosure and a grievance if it arises in the workplace?
Well, I guess whistleblowing is really about wrongdoing, isn't it? A breach of an act, an offense that may have criminal consequences, or ethics point. Let's say even sexual harassment, I think, would be a whistleblowing situation. But grievance is really sometimes about poor relationship between an employee, a supervisor, a manager, and another employee, right? It calls for conciliation, or some sort of a meeting of minds and understanding one another. So I think that would be the broad principle I would go by. One that has criminal consequences or legal exposure, and one that is really about managing, unhappiness and relationships. Yeah.
Kim, would your distinction be in the same place or somewhere else?
Yeah, it would be, David. I agree with Julia on that point. I think certainly the grievance side, people think it's a big deal, that their boss is horrible to them, there's a lack of understanding of what they are blowing the whistle on, and I think it's interesting. It's getting more complicated all around the world, I'm sure, but in Australia we now have health and safety legislation creeping into this as well. And I think you started off the conversation by saying, "Oh, not you again. What do you want this time?" I think if that type of attitude goes on in Australia now, then there's avenues for psychosocial hazards to be raised, so that you're not taking my complaint seriously. I'm feeling unloved, and I've now developed a mental illness that requires compensation. So yeah, it is important. We spend a lot of time dealing that distinction, as Julia said, between that grievance and then the actual statutory issues of fraud, corruption, bribery, and all the other whistleblowing serious allegations.
I have suffered the sort of terrible mental injury which can only be resolved by cash, in other words. Yeah, okay. Well, we'll draw a veil over that. What about record keeping? And of course, there's going to be records kept of the disclosure of steps to investigate and so on. But is it a good idea to retain thematic records so that you can identify if the same complaints come up over and over again? Or are they potentially just a hostage to fortune in later litigation? What would you say? Catherine, can we start with you on that one?
Sure. I guess I'll have to give a lawyerly answer and say it depends in terms of the documentation. There is variance depending on the type of complaint and what type and to what extent you're investigating. So I often share with clients the word investigation could mean interviewing 2 individuals, interviewing 20. It could be something internal versus external, which changes the landscape of things. So, generally speaking, you should, if a complainant or a whistleblower provides you with documentation, I recommend you maintain that certainly as part of the complaint. Any documentation confirming that you did look into it and didn't sweep it under the rug or tell the whistleblower to go away is helpful. But whether or not, detailed notes are necessary, whether a written investigation report is necessary, whether maintaining every single piece of, post-it is necessary, that would depend on the particular situation. Of course, if there's a litigation hold notice in place, that's a different story. And you want to maintain everything because you certainly don't want to be accused of destroying evidence intentionally or unintentionally.
Yes, which probably takes us to the data protection question. GDPR says you shouldn't retain personal data for longer than necessary, summarizing wildly. But you could retain the basic theme of a disclosure for much longer than you need retain any of the personal data relating to it. Is that the position generally? Julia, for example, would you suggest that people say, even just that there's a harassment complaint in a particular department, it's all gone and dealt with, but we know it was there in case it happens again?
I would think that you need to retain, for as long as they, I would say be guided by the statute of limitation in terms of claims, right, back to the company. So it can be far longer. In some cases, of course, 3 years, 6 years, unless the legislation, let's say there is particular legislation like in Korea, right, Whistleblowing Protection Act, and which I think requires 3 years for you to retain, right? But otherwise, I would say it's safe to go by the limitation period preserve because there may be claims against you. So I will stand guided by that policy. Okay.
Anybody else with thoughts on that?
No, this is also the position that the EU directive has taken. So the statute of limitations for the infraction that was reported on, and you keep that information up until that time. I think in that respect, David, as you mentioned, data minimization is important with all internal investigation. This is the case, but specifically also with investigations following a whistleblowing report, is that very often this report will lead you to other information, and what started or may have started as a small investigation tends to snowball into a much bigger thing. And it's important in that respect to keep the scope of the investigation very closely related to the actual subject topic of the report, and to do away with the information that is not relevant for that specific topic of investigation.
All right. And then one point I should have asked about in terms of manager training. UK law makes the employer essentially vicariously liable for the retaliatory actions of the employee, unless the employee has been, as in the person complained about rather than the person doing the complaining, unless that person has been told expressly not to retaliate. So is a sensible first step in each of your jurisdictions to find the person the allegation is made against and say, look, I know you're going to find this difficult, upsetting, embarrassing, whatever it is, but you must not take that out on Snooks or whoever made the complaint. Is that a good thing to do?
In the US, not necessarily. While there are no, we advise that you cannot promise complete confidentiality. However, to the extent confidentiality can be maintained, that would be ideal. And in some cases, the wrongdoer may not need to be apprised of, the specific information or the specific whistleblower. We don't have that defense in the US, where if you tell somebody not to retaliate, that can be helpful. Managers actually can be personally liable, which is why training is critical. And retaliation can be a separate, violation or act of a problematic conduct beyond what the whistleblower was initially complaining about. So I think advising generally no retaliation with respect to the wrongdoer as well as all witnesses is recommended, but identifying the wrongdoer and saying, hey, we've heard this about you, don't do this, that may not be as productive as in some other jurisdictions, depending on the circumstances.
Kim, views?
It's interesting, David, in Australia, we've got our first case. So the Australian Securities Investment Commission is the enforcement body. And just this year, they've commenced proceedings against an employer that effectively, some say retaliated, but didn't protect the whistleblower. It was a coal mining company. They overstated their coal reserves. The employee blew the whistle on them, and the company effectively retaliated against them, and they suffered a detriment. And that's a prohibition in the legislation. And so the government authority is prosecuting the 4 directors, the chairman and the CEO, etc., for that type of action. So it'll be great to have a decision in Australia to see how that plays out. But that's the theory of the legislation that's designed to protect that.
Julia, a view on that? Put a shot across the bows or not?
Yeah, I know. I think I tend to take the view that it is good to kind of give a warning to the person being complained against, right? Not to retaliate. Maybe, of course, the idea is not to reveal the identity of the whistleblower, but to say that, whatever is the outcome of the investigation, you should not be looking, going on a witch hunt and taking any particular action towards the potential complainant or whom you identify as the complainant. But I think one of the key points, or rather one of the issues that my clients may face, particularly for those who have been complained of, they often are the line managers, for example, or person in supervisory role, and they find themselves very much afraid, to conduct, let's say, review, right? Because a lot of the whistleblower can be poor performers, for example, who are unhappy, who feel that, something has not been done right. They want to take a response. They want to make sure that, their voices are heard and whistleblow. So there is this tension now, right? If I do a performance review for somebody who was whistleblown, am I taking retaliatory action? So that becomes a really difficult one for the company to manage and also for the line manager. So I think the leading from this whistleblowing, let's say having a policy in place, is the not just a training of that, but also a training in terms of how to run a proper performance review, how to manage your employees or your subordinates, right? So that you rightly divide and not wade into the situation where you're deemed to be retaliating against somebody who has whistleblown a complaint against you.
So mixed views on doing it after the event, but everybody would agree that in general management training, it would be a good idea to say, if this happens, don't go on a witch hunt, don't hunt down and kill the person you think did it. But yes, okay, fine. All right.
As part of the investigation, as you speak with witnesses, which will presumably include any wrongdoers, you can provide that, warning as well. So.
Yeah,
yes.
that's true.
Also important to issue the warning not just to the potential offender, but also potentially to colleagues who may be sympathetic to their case, because very often retaliation will also come not directly from the offender, but someone in their surroundings. And as an employer, at least under the directive, you'll also be responsible for that type of retaliation.
Yeah.
And I'll add, in the US, retaliation, unsurprisingly, is also broad. So it's not as black and white as you're fired or you're demoted. Even the cold shoulder can be viewed as retaliation.
Oh, even just, yes, in the UK, even just funny looks in the lift, that's enough. So it's a very, very low bar indeed. All right, that is more or less it for today. Thank you to speakers, thank you for participating. If you've got questions, we did get one, but we'll come back to that through the blog. Very pleased to hear from you. Please drop one of us a line afterwards. A brief and shameless plug, can I show you this? This is, don't know if you can read that, but this is about investigations in the UK. I think it's pretty good. I wrote it, so just as well, really. And it will give you a cradle to grave perspective on doing your own in-house investigations. It is it's quite a long piece of work. It will show you that it's easier than you think, and at the same time perhaps more complicated. So we should also mention, while we're about it, that as a firm we will do in-house investigations if that helps, if it gets all of this stuff off your plate. Separate thing, if you want that guide, then as I say, let me know. We'd be very happy to send it to you. In the short term, thank you for your time. Look out for the recording, which will be due shortly. Go and look at our blog, where you will find more about this and the answers to the specific questions which have been raised. And do please join us on the 23rd of June, I think it is next week, when Marga will be back on stage doing Belgium in more detail, accompanied by partners from France and Germany covering those jurisdictions as well. And then I think the week after we have another one covering some more of Europe and Central Europe. In the meantime, really appreciate your time. Thank you very much for joining us. Good afternoon.
Thank you.